Where Harry has crossed over the line and really should be made to stand down and be stripped of all of his royal privileges is in having attacked Mr. Justice Nicklin.
The Daily Mail are pursuing Prince Harry for unlimited legal costs, and they're looking for $13.3 million from the claimants up front.
The realisation for Harry has come later, but of course, a big part of his absolute, I would say, psychotic determination. I hope you don't think that's going too far.
This was just one of the objectives of this lawsuit. Another was to extort millions of pounds criminally, unjustly, and unfair.
Forget the courtroom for a second, because what happened after the verdict may have shocked even more people than the case itself. Lady C says Prince Harry should lose his HRH, not because he lost in court, not because of the millions he could now be responsible for paying, but because of the explosive comments he made after the judge delivered the decision. And once you hear exactly what Harry said about Justice Nicklin, along with the fierce backlash that followed from Britain's legal establishment, you'll understand why Lady C believes he should never again be addressed as Prince. This story didn't end with the ruling. In many ways, that's exactly where the biggest controversy began. But before we get to Harry's response, you need to see just how overwhelming this courtroom defeat really was. The judgment stretched across an incredible 436 pages, covering 97 allegations of unlawful information gathering, and every single one of those claims was dismissed. Once you understand how decisive that ruling was,
it is a whitewash, and that but for it being a whitewash and Mr. Justice Nicklin being corrupt, Harry would have prevailed. Now, Harry is a prince of this realm. It is totally unacceptable.
I believe there were 97 claims against the Daily Mail. All of them dismissed. Normally, it's like a parking ticket. Normally, you'll get done for something. But every single claim was thrown out. That's unusual, isn't it?
It is, and it's probably worse than that as well, Mark, because I think it's 57 articles were examined in detail in the judgment, but 32 were materially different.
I mean, there is no way that this case is an ordinary case. It is corruption from beginning to end. And Harry knows exactly what he has done. And Harry thinks he's been able to get away with it because he's a prince of the realm. He should not be allowed to get away with it precisely because he's a prince of the realm.
Harry's reaction afterward becomes even more astonishing, and you'll see why so many legal figures believed he crossed a line that should never have been crossed. The judge concluded that Harry and his fellow claimants had failed to prove that any of the stories they complained about were obtained illegally. Suspicion, he wrote, is not proof. For most people, that would be the moment to walk away quietly, reassess, regroup. Harry chose a different path. He and Baroness Doreen Lawrence released a joint statement calling the ruling a complete and obvious whitewash. They said the lengths the court went to in order to exonerate the Mail were as shocking as they were totally unwarranted. They accused Justice Nicklin of ignoring evidence, of inconsistency, of reaching conclusions that defied common sense.
Having attacked him for being corrupt, having asserted that it is a whitewash, and that but for it being a whitewash and Mr. Justice Nicklin being corrupt, Harry would have prevailed. Now, Harry is a prince of this realm. It is totally unacceptable for a prince of this realm to attack one of the most senior judges in this country for corruption, when it is clear that his actions have been anything but corrupt.
But when you think that the judges are there to represent the court who are appointed by the king. Remember, it's the
Yeah.
crown that prosecutes. The judges are there representing the king. It's the king against so-and-so. It's the crown against so-and-so in a court case. So for the son of the king to come out and criticize the judicial system in this way is quite extraordinary.
Now, there's a difference between saying you disagree with a ruling and saying the judge who made it is corrupt, and Harry's words landed squarely in the second category. This wasn't a frustrated litigant venting on social media. This was a prince of the realm publicly attacking from one of the most senior judges in the country. The response from the legal establishment was immediate and severe. Alex Chalk, a former Justice Secretary who served under Rishi Sunak, called Harry's comments over the top, personal and unacceptable. He made a point that most people don't think about. Judges act in the name of the king. They swear an oath of allegiance to the sovereign. When Harry attacks Justice Nicklin, he isn't just attacking one man's judgment. He's attacking the authority of the crown, his own father's authority.
And that Harry's actions have been corrupt, and that his legal team's actions have been corrupt, and that there has been serious criminality, which so far everybody is resiling away from. I don't think they should. This case deserves the absolute spotlight shone upon it, and it deserves to be treated with the harshness that it warrants in terms of.
And I think that may even be reflected in the costs now, because what Associated Newspapers are saying is, look, immediately after this decision was made, Prince Harry comes out, says it's a whitewash, casts aspersions on the judge and the way the case has been handled. It's not a sensible approach for him to do. I think even the other claimants have tried to move against that decision and say, well, look, that was him. Part of the arguments that we're now seeing in court today, probably see tomorrow, is that some of the claimants are saying, well, look, this shouldn't affect the other claimants.
Sir Robert Buckland, another former Justice Secretary, echoed the same sentiment. And then came the most striking response of all. Lord Burnett, the former Lord Chief Justice of England and Wales, the man who was once the most senior judge in the country, stood up in the House of Lords and spoke about what he called the growing vilification of judges. He said judicial independence is undermined when judges are attacked personally or their integrity is questioned. The warning that echoed through the House of Lords carried far more weight than many people expected. Lord Burnett described it as a direct assault on the independence of the judiciary, sending a powerful message across Britain's legal system. He never mentioned Harry by name. He didn't have to. Everyone listening already knew exactly who the remarks were aimed at.
What Associated Newspapers are saying is, look, this shows the extent to the blame culture that they want to say, and they will not accept the judgment. So they're continuing to say and try to get public opinion to say the Daily Mail are still wrong, even though they've been proven to be right with the court judgment. So that may be taken account of by the judge. It doesn't reflect well on Prince Harry and some of the claimants.
And here's the part that could cause Harry even more trouble. Associated Newspapers is now pointing to his whitewash statement during the costs hearing. Their legal team argued that Harry's comments after the verdict show the claimants refuse to accept the court's decision, and they say that attitude should be considered when the court decides how much they must ultimately pay. So Harry's remarks didn't simply create another public relations problem. They may have made an already difficult financial situation even more expensive. And the figure now hanging over him was already staggering before he made those comments. Associated Newspapers says it spent £34.5 million defending the case, and it wants every pound returned on what is known as an indemnity basis. That means the losing side could be ordered to cover the full legal bill without the usual assessment of whether those costs were reasonable or proportionate. Their lawyer described the entire lawsuit as a banquet of litigation, filled with sweeping allegations of criminal conduct involving dozens of journalists, claims they argued fell apart once the evidence was carefully examined. Now, they say, The people who brought the case should pay for the enormous legal battle that followed. The claimants did have insurance, and at first that sounds like a safety net. But that confidence quickly disappears when you hear the numbers. The total insurance coverage shared across all 7 claimants, Harry, Elton John, Doreen Lawrence, Elizabeth Hurley, Sadie Frost, David Furnish and Simon Hughes, was £16 million. Associated Newspapers' legal bill alone is more than twice that amount. So before the court even begins deciding who owes what, there is already a gap of nearly £20 million that no insurance policy appears to cover. Associated has also requested an interim payment of almost £10 million, not sometime down the road after lengthy discussions, but within just 14 days. Top lawyer Marcus Johnston broke down Harry's possible financial exposure during an appearance on The Mark Dolan Show. He said the amount could reportedly reach between $10 million and $15 million before explaining the part many people found especially significant: joint and several liability. Because the claimants share responsibility for key parts of the lawsuit, Associated does not have to pursue every individual equally. Instead, they can legally focus on one person and seek recovery of the full amount from that individual. On top of all that, reports claim Harry agreed to cover Doreen Lawrence's legal costs as an incentive for her to join the case. If that is accurate, he may not only be responsible for his own legal exposure, but could also find himself carrying hers as well, making the financial pressure even greater. The financial pressure didn't stop with the courtroom defeat. According to legal commentators, the numbers involved could reach a level where years of earnings disappear almost overnight. Reports have suggested that Spare earned Harry around $20 million, but once agents, managers, public relations teams, taxes and other expenses are taken into account, that figure could be reduced dramatically. Under one possible scenario discussed by analysts, much of what he earned from the memoir could be consumed by this single legal battle. Marcus Johnston then made an observation during his television appearance that many viewers found especially striking. He said Harry likely doesn't have this kind of money sitting readily available, and he warned that the legal and financial consequences may still be unfolding. According to Johnston, there is a genuine possibility that the claimants could eventually begin turning against one another. He suggested Harry could pursue legal action against his own lawyers. Elton John might seek to distance himself financially from the case. The Daily Mail could pursue individual counterclaims. And perhaps most significantly, the insurers might decide not to pay at all. If an insurer concludes it was given an inaccurate picture of the strength of the evidence when the policies were issued, it may argue that it has grounds to deny coverage, much like a car insurance company that discovers false information on an application. Johnston summed up what could happen next with a phrase that quickly caught people's attention. He said the situation could become like rats fighting in a sack. But even before any of those possibilities unfold, one question has already started circulating among many observers. How did this lawsuit ever reach a full trial if the supporting evidence was ultimately found to be so weak? One of the trial's most closely watched moments centered on Charlotte Griffiths, the editor-at-large of the Mail on Sunday. Harry's account was clear and straightforward. He said that once he realized she was a journalist, he immediately ended all communication. According to his version of events, it was a clean break and entirely his own decision. Charlotte Griffiths gave the court a very different account. She described what she said was a friendship that continued over several months. She told the court her nickname for Harry was Mr. Mischief. She spoke about personal conversations, movie recommendations, and what she referred to as snuggles. Then she made the statement that became one of the most discussed moments of her testimony. According to Griffiths, she was the one who ended the friendship, not Harry. She said she was the person who decided to cut off contact. Keep in mind, this lawsuit focused on whether the Daily Mail unlawfully obtained Harry's private information. His friendship with Charlotte Griffiths was not the central issue. However, it became relevant because it touched on the broader question of credibility and whether the court could rely on Harry's version of events. That question was about to face another challenge. Harry also told the court that he had never attended a festival. During cross-examination, counsel for the Mail calmly pointed out that Harry had previously written about attending a festival in Spare, his own memoir, published under his own name, creating another point the court was asked to consider. As more details from the judgment emerged, the picture became even more difficult for Harry's side to defend. According to the ruling, 32 of the 57 articles examined by the court were argued using positions that had materially changed from the original claims. Another 24 allegations were found to have no sufficient supporting evidence at all, adding to the scale of the setback described throughout the decision. Marcus Johnston, a lawyer known for handling some of the country's most serious criminal cases, said he personally would not have felt comfortable taking a case forward with evidence of that standard. His remarks added to the growing discussion about how the litigation had been prepared before it ever reached the courtroom. Then attention shifted to Doreen Lawrence. The criticism directed toward her has been intense, and many commentators say it stems from a point that resonated strongly with the public. The Daily Mail was the newspaper that famously placed her son Stephen's killers on its front page. It published the headline describing them as murderers before any convictions had been secured, taking a significant legal and financial risk in doing so. For many observers, that history made her decision to become part of the lawsuit especially controversial. Marcus Johnston carefully suggested that Doreen Lawrence may have been the most reluctant claimant, and that she was persuaded to join the case by Harry and his legal team. He also said he believes she may now regret becoming involved. Public reaction, however, has generally been much harsher. One widely shared online comment, receiving more than 400 likes, described her decision as disgraceful because she had taken legal action against the newspaper many people credit with helping keep attention on her son's case. Whether or not everyone agrees with that view, similar reactions appeared repeatedly across online discussions. So, with questions surrounding credibility continuing to grow and legal costs still climbing, many expected Harry to step away from the spotlight for a while. Instead, attention quickly shifted to Meghan's public activity, and some commentators argued that it only intensified the conversation. Within days of the court defeat, Meghan's Instagram became noticeably more active. Images showed what appeared to be an idyllic family life in Portugal. Other posts featured the children visiting Diana's childhood home at Althorpe, alongside carefully selected photos of Harry looking relaxed, rugged, and devoted. To many online observers, the collection projected a single message: "We are fine, we are happy, we are unbreakable." The timing attracted immediate attention because the posts appeared just after the court ruling, following the controversy surrounding the whitewash comments, and shortly after Lady Colin Campbell made claims that some commentators believed had unsettled the couple's public image. Sources quoted by journalist Rob Shooter then added another layer to the story, alleging that Harry and Meghan have been leading increasingly separate lives, a claim that quickly fueled even more speculation. Behind the carefully staged public appearances, commentators have continued pointing to signs that Harry and Meghan may be living increasingly separate lives. The discussion isn't just about different work projects anymore. Critics claim it is about different priorities, different routines, and spending much less time together than many people assume. Whether those observations are accurate or not, they have become a recurring topic across entertainment coverage and online debate. Lady C pointed to Meghan's MasterChef Australia appearance as another example of what she believes is Meghan struggling under public scrutiny. According to Lady C, it appeared Meghan was uncomfortable with the subject matter, uncertain about what she was doing, and unable to connect naturally with the people around her. Those are Lady C's opinions, but they quickly became part of a much wider discussion online as clips from the appearance continued circulating across social media. Reports discussed by commentators also claimed that some members of the production crew were relieved when filming ended. Those reports have not been independently verified, but they added to the growing conversation surrounding the appearance. Lady C also referenced the sociopath next door, a book written by a Harvard professor, while explaining her personal interpretation of Meghan's public behavior. She referred to the book's broader argument that some individuals consistently give off signals that make other people feel something is not quite right, even when those individuals are trying to appear completely ordinary. Lady C argued that Meghan displays those kinds of signals repeatedly. That assessment reflects Lady C's personal opinion, but it became another talking point among people already debating Meghan's public image. Then another detail began attracting attention and pushed the conversation even further. A few days later, Meghan attended a movie screening in Los Angeles on her own. Observers quickly noticed that she was not wearing what appeared to be her wedding ring. On its own, that detail could have many perfectly ordinary explanations. People remove rings for comfort, travel, work, or personal preference all the time. However, because it happened alongside ongoing speculation about the couple's relationship, the missing ring immediately became one of the week's biggest discussion points across celebrity media and social platforms. Lady C then went much further than most commentators were willing to go. She said she had received information from American sources whom she described as people holding official positions and respected standing, individuals she identified as liberal Democrats, whose identities she said she had verified. According to Lady C, those sources approached her rather than the other way around. She claimed they told her Harry had been seen spending time with someone new and that there were mutual feelings involved. These claims remain unverified and should be viewed as allegations rather than established fact. Dan Wooten, who has covered Harry and Meghan for years, added another layer to the discussion. He argued that both Harry and Meghan have been preparing for the possibility of life after their marriage for quite some time. He pointed to previous reporting that claimed Meghan had explored the possibility of a post-divorce book deal. He also highlighted reports that there is no prenuptial agreement specifically covering Diana's jewellery, meaning those items could become part of future legal negotiations if the couple were ever to separate. Then, Lady C added one final claim that she suggested should deeply concern Harry. She alleged that Meghan possesses recordings involving him and implied that if Harry were ever to write another memoir criticising their marriage, Meghan would be prepared to respond publicly first. Whether those claims proved true or not, Lady C argued that the carefully curated photos Meghan recently shared could end up creating consequences neither of them expected. According to her, every one of those images is about to blow up in Harry's face for a reason Meghan never considered. Now step back and look at the bigger picture, because this is the point where many commentators believe the entire security argument starts to unravel. According to the timeline discussed by several royal commentators, Harry and Meghan flew from Portugal to London, spent time at Highgrove, and later travelled into the Scottish Highlands. They crossed a huge portion of the United Kingdom without any publicly reported security incident, without reports of police intervention, and without any confirmed threats emerging during the journey. Perhaps the most surprising part was how little public attention the trip appeared to receive while it was happening. According to reports, very few people even knew they were in Britain until photographs surfaced afterward. That timing immediately fueled another round of debate about Harry's long-running legal battle over publicly funded security. Royal commentator Neil Sean said a source he attributed to the Home Office raised what many people viewed as a straightforward question: if someone can travel across the country without attracting significant public attention or creating a visible security issue, what evidence exists to justify millions of pounds in taxpayer-funded protection? That question has become central to the broader public debate, even though Harry has consistently argued that his security concerns are genuine. Another point frequently raised by commentators involves the political climate. The current British government is generally not viewed as especially enthusiastic about promoting the monarchy. Because of that, some analysts argue that if even this government remains unconvinced by Harry's case for state-funded protection, it makes his legal position considerably more difficult. Whether people agree or disagree with Harry's arguments, many observers believe that each unsuccessful legal ruling makes the path forward even steeper. Critics have also pointed to Meghan's social media posts following the trip. They argue that photographs showing the couple walking peacefully through the countryside unintentionally strengthened the case made by Harry's opponents. To those critics, the images projected calm, privacy, and normality rather than imminent danger. Others disagree and point out that photographs capture only isolated moments and cannot prove the absence of genuine security risks. Even so, the debate has continued to grow because those pictures became widely shared online. That brings many people to the question dominating royal discussions. It is no longer simply about what went wrong during the court proceedings. Instead, attention has shifted toward what some commentators believe should happen next. Lady Colin Campbell has been particularly outspoken on that subject. According to her commentary, Harry should face significant constitutional consequences for publicly criticising the judge after the ruling. Lady C argued that losing the case itself is not the central issue. In her view, the greater concern is what she describes as Harry's attack on the authority of the judiciary and, by extension, the institution of the Crown. She then outlined what she believes those consequences should include. According to Lady C, Harry should lose the right to use HRH. She also argued he should no longer hold the title of Prince in public life, should be removed from serving as a Councillor of State, and should simply be known as Mr. Henry Mountbatten Windsor. Those are Lady C's personal views, but they have generated considerable discussion among royal watchers. Lady C went even further by arguing that if King Charles chooses not to act, then, in her opinion, he would be neglecting an important constitutional responsibility. That statement sparked another wave of online debate, with supporters and critics offering sharply different opinions about whether the monarch should intervene at all. Around the same time, attention also turned toward a Change.org petition that attempts to explain which actions are legally available to the king without requiring Parliament. Supporters of that petition argue that the monarch could remove the HRH style, discontinue the use of the Prince title in certain circumstances, and update the official royal website to remove Harry and Meghan's profiles if such decisions were made. However, they also note that other constitutional changes involve entirely different legal processes. For example, removing the Duke of Sussex peerage, altering the line of succession, or changing Harry's status as a Councillor of State would require legislation approved by Parliament. Those are not powers the monarch can exercise independently under current constitutional arrangements. Commentators often point to Prince Andrew as an example of how rapidly changes can occur when both the palace and Parliament are aligned. While every situation is different, they argue that precedent demonstrates constitutional changes can happen when sufficient political and institutional support exists. Dan Wooten then highlighted another issue that, according to him, deserves more public discussion. Harry currently remains fifth in the line of succession, following Prince William, Prince George, Princess Charlotte, and Prince Louis. Wooten argued that although the chances of the line of succession changing dramatically are extraordinarily remote, constitutional systems are built to prepare for unlikely events. He also referenced previous reports that the late Queen Elizabeth II had expressed concerns about William travelling by helicopter with his children because of the obvious succession implications. Under the current constitutional framework, if an unimaginable chain of events were ever to occur affecting those ahead of Harry, he would eventually become king. His wife would become queen consort. That is not speculation about current events, but simply reflects how the succession rules operate today. For some people across the United Kingdom and the Commonwealth, that reality is precisely why discussions surrounding Harry's constitutional position continue attracting attention. Others argue the scenario is so unlikely that it should not drive present-day decisions. Regardless of which side people take, it remains a subject that consistently generates strong opinions whenever Harry returns to the headlines. Lady C closed her discussion with perhaps her strongest statement of all. She argued that concern over how Harry might react should not prevent accountability if accountability is warranted. In her view, consequences should never be avoided simply because they may be uncomfortable for the person involved. Whether people agree with Lady C's conclusions or strongly reject them, one thing is difficult to ignore. This story has moved far beyond a single court ruling. It now touches on questions about public trust, constitutional responsibility, public funding, media strategy, and the future role Harry should or should not play within the royal family. Those debates are unlikely to disappear anytime soon. Now it's your turn. Do you think Lady C has gone too far with her demands, or do you believe Harry should face constitutional consequences after everything that's happened? Share your thoughts in the comments below. We'd genuinely like to hear where you stand on this debate. And if you enjoyed this breakdown and want more in-depth coverage of the latest royal developments, don't forget to like this video, subscribe to the channel, and turn on notifications so you won't miss the next update.